If you're like us, you're probably tired of flipping through outdated and expensive regulation books and struggling to understand the rule or guidance you're after. eRigs is the first web and mobile app version of the Federal Motor Carrier Safety Regulations, helping fleets of all types and sizes better access and understand their regulatory obligations. eRigs is always up to date and allows fleet safety professionals to not only read the rules, but also dig into FMCSA guidance and learn more about complex regulatory topics from industry experts. Highlight, bookmark, and take detailed notes right from the app and access them on any of your devices. And easily share a digital version of the regulations with your drivers so that they too can better understand the rules. eRigs was developed by safety professionals for safety professionals. Try it out for free at erigs.app. All right, hey everyone, welcome to episode 55, Trucksafe Live, show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon, it's Tyler. We are with Trucksafe and Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting-edge safety programs. Happy Veterans Day to everybody tuning in. Thanks to all the veterans and your families. Appreciate everything you've done, sacrifice you've made for our country. Welcome to everybody who is here with us. Sorry for the technical glitch here. For some reason, this didn't go live on LinkedIn. So I put a note. Hopefully you can tune in here on YouTube or Facebook, and then we'll post it again after the fact on LinkedIn. But if you're here with us, say hey in the comments so we know who's around. And as we go along today, if you have any thoughts on this topic, or questions about it, drop them in the comments and we'll get to them as we go. Obviously, this is a special episode of Trucksafe Live, breaking news in the industry pertaining to the FMCSA's non-domiciled CDL interim final rule that it passed or that it put into effect it was September 29th, I think is when it went into effect. And now a federal court has halted it, at least temporarily, and so wanted to jump on here and talk about what exactly that means and kind of what's at issue in this pending federal court case and what fleets and drivers should expect over the coming weeks and months. So that's the point of today's show. That's what we're going to do. I want to first thank the sponsor of this show, which is Project 61. It aims to improve the life expectancy of CDL drivers by raising awareness, providing resources, and educating drivers on a healthier lifestyle. Learn how you could support the movement over at project-61.org. A couple things to mention about Trucksafe before we get started here. First up, I'll mention our Trucksafe network. If you're not a member of this, I'd encourage you to join it. It's free to join over at trucksafenetwork.com. This is the space we've built for safety professionals to gather together, learn from one another, ask questions, and also access all of our DOT-related content that we push out on a regular basis. So you can join over there, trucksafenetwork.com, or scan that QR code and download the app on the App Store or the Google Play Store. And then our newsletter, if you're not following our newsletter, this is where we're pushing out all of the breaking industry news and our analysis of it. So if you need a resource to keep up to speed with all of that stuff, our newsletter would be a great place to start. Trucksafe.com/newsletter is where you can do so. Trucksafe.com/subscribe is where you can subscribe to the newsletter. So hope to see you over there. All right. So as I said, federal court, D.C. Circuit Court of Appeals, to be exact, has issued a temporary stay of the FMCSA's interim final rule on non-domiciled CDLs, meaning the agency is restrained from enforcing that rule temporarily and the cutbacks that it made to non-domiciled CDLs pending further order of the court. So we don't really have a plan for this show, so we're just going to kind of break down and give you our thoughts on what this will mean. So, maybe we could start off for folks who aren't even familiar with the non-domiciled CDL rule. That's probably a good place to start. We've done other shows on this. If you want to deep dive into it, go check those out. We've also got some articles on the topic at trucksafe.com if you're interested. But, high level here, non-domiciled CDLs, for folks who aren't familiar with them, are a special category of commercial driver's licenses issued by state licensing agencies pursuant to authority granted to them by the FMCSA. So this is, the CDL program at its heart is an FMCSA program. It's a federally regulated program administered by the states. FMCSA gets to set the rules pertaining to the CDLs that get issued by the states. So I guess that's the first point I'll make, is that, this is an issue where we're seeing some states push back, but ultimately this is a federally regulated program where FMCSA gets to set the rules, assuming its rules are within the confines of the authority that Congress has granted to FMCSA. So non-domiciled CDLs are a particular type of CDL that gets issued most notably or primarily to foreign nationals. So drivers who are residents of other countries, putting aside Mexico and Canada, they don't get these non-domiciled CDLs. They can operate under their own country's CDLs in the U.S. But assuming you are a resident of another foreign country and you want to operate commercial vehicles that require a CDL in the United States, your only option is to get a non-domiciled CDL. These have been issued by the states for decades at this point. There are specific rules pertaining to who's eligible to get these types of licenses, and that's been true for many years. The problem has been many states haven't been following those rules or haven't been closely tracking who they are issuing these to, and FMCSA has recently done a fairly extensive audit of the state's issuance of these types of licenses and have found what they say is widespread abuse of these types of licenses and their issuance. And so that has led FMCSA to crack down on eligibility for these types of non-domiciled CDLs, who's entitled to get them in the first instance, and also cracking down on the states and making sure that they are issuing them correctly and pursuant to those regulations. So that interim final rule, like I said, went into effect September 29th of 2025. And the first big restriction that it put down was that it limited the universe of drivers who are eligible for these non-domiciled CDLs. So in the past, we had seen asylum seekers, DACA recipients able to get these non-domiciled CDLs, but under the interim final rule, only 3 categories of foreign drivers can get them. Those holding H-2A, H-2B visas, and treaty investors, whatever that means. Those are the foreign drivers who are now eligible under the interim final rule to get the non-domiciled CDLs. The second big thing that the interim final rule did was make clear that assuming you are eligible to get a non-domiciled CDL, you're only eligible to get it for the length of your work authorization or 1 year, whichever is less. Apparently in their audit, they found a substantial group of drivers whose non-domiciled CDLs extended for multiple years at a time. But now 1 year is the maximum length that someone could get a non-domiciled CDL under that interim final rule. It also put some pressure on the states to do more careful vetting of these drivers who are seeking these non-domiciled CDLs. No longer can the states accept just an employment authorization document. They have to get an unexpired foreign passport and a Form I-94 from these drivers to be able to process them. And the non-domiciled CDLs themselves have to be clearly marked on their face as non-domiciled CDLs. So those are the big changes that we saw with this interim final rule. And, it's wrapped up in the politics right alongside English language proficiency. And so it's garnered a lot of media attention and certainly the talk of the town in the industry. And so because of that, I mean, it was probably, we saw this coming, but we knew FMCSA was going to probably get sued about one or the other or both of these rules that it has put out. And here we are. So two different groups have sued FMCSA with respect to this interim final rule on non-domiciled CDLs. So Tyler, you want to walk us through who those groups are that sued FMCSA?
Yeah, so one is a Martin Luther King Jr. County, and the other is a
In
group
Washington State.
in Washington State, and then another is some individual drivers, along with some unions. Um, the AFL-CIO, there's a American Federation of Teachers union that were part of the second petition. So there's two petitions before the DC Circuit that filed. Both filed the motions for stay after they initially filed the petition for review. So the petition for review is really looking at, hey, did the FMCSA, were they okay in publishing this rule? The motions for stay are kind of an injunctive or emergency relief to say, hey, while the court, we're going to have some, briefing on, what support the FMCSA had in, promulgating this interim final rule. But this stays are really important, for, hey, this rule can't go into effect until after the court has kind of seen and heard all the briefing and arguments that supports the rule. Whether or not the FMCSA complied with the Administrative Procedures Act, and really it's big that they've made these challenges at this point. The rule right now is not in effect.
Yeah. So you mentioned that we have two petitions, both filed in the United States Court of Appeals for the DC Circuit. They were consolidated by the court because of the similarity of issues under the caption Jorge Lujan et al. Versus FMCSA. So that's where all of the filings are being made. As you pointed out, Tyler, this is, as is true with all federal court cases, getting to the merits of the plaintiff's case is going to take time. And so what you'll see in a lot of cases, and what we see here, is that the plaintiff will say, well, while we're waiting for the court to rule on the merits of the case after all of the briefing and all of the discovery, if there's going to be any and that type of stuff, we need emergency relief. This rule is in effect currently, and it's hindering our clients' options, at least in the case of the owner operators who are involved here, who presumably have lost their licenses or will at the time of renewal. And so they are seeking emergency injunctive relief, essentially asking the court to shut down the effect of the rule pending the court's resolution of the merits of the case. And so they did that in the form of this emergency motion for a stay pending review. And yesterday, November 10th, the court ruled, it didn't actually rule on the motion for stay. It simply said, and here's the text of the actual order: upon consideration of the emergency motions for stay, the court is ordering that the FMCSA's interim final rule be administratively stayed pending further order of the court. It goes on to say the purpose of this administrative stay is to give the court sufficient opportunity to consider the emergency motions for stay pending review, and should not be construed in any way as a ruling on the merits of those motions. So this is a little bit unique from other cases I've seen, where the court's not granting the stay that the parties have requested. They're staying it pending their review of the motion for stay. So
Yeah.
it's a stay in advance of the decision on the longer term stay, which is what the plaintiffs are looking for.
Yeah, what's interesting about this is essentially, the way I'm looking at this is that the court has ordered the agency to stay it. And what's interesting about this is at least some of these plaintiffs filed a request for the FMCSA to stay this before they filed their petitions for review.
Yeah.
So they had asked the FMCSA outside of the courts, hey, can you stay this rule, presumably because of all the same reasons listed. Hey, you didn't comply with the Administrative Procedures Act, but they had asked for relief from the FMCSA directly prior to doing so with the court. So I think you're right. Yeah, the court's just saying, hey, FMCSA, you have to stay the rule. We're going to take a look at everything else in the meantime. I mean, the effect is the same.
Yeah, same effect. But
Yeah.
probably shorter in term. I imagine we don't have any dates yet is something else to note here, is we don't know when the court will ultimately rule on the pending motions for stay. I mean, that will be the next thing, presumably, that they will do is rule on the motions for stay. And we don't have a timeline for that, I don't think, do we, Tyler, of when that will happen?
No, not on those motions. There is, kind of a standing scheduling order on, motions related to the petitions filed by the
Yeah.
plaintiffs themselves, and, dispositive motions, all those things go into December, first week of December. So there's going to be more motion practice, but yeah, I imagine that the court's going to have to actually, or I would assume would have to rule on these motions for stay itself, and stay the case via its own power.
Yeah, and if
Before
it
getting to
all,
merits.
ultimately the court, in the context of ruling on these motions for stay, the court will be deciding: are we going to halt this rule longer while we decide the merits of the underlying case, or are we going to let it take effect as it had September 29th, go back into effect, and while we still litigate this case? And then ultimately, if we find in favor of the plaintiffs, maybe we overturn it at the end. But the point of this motion for stay is, what are we going to do with this rule in the interim while the court is looking at whether the plaintiffs have a legitimate gripe with the rule or not? And so that's kind of where we're at. And so the interim final rule is stayed at the moment. So maybe before we get into what that exactly means for the rule, maybe let's take a quick look at the case itself. You've already kind of hinted at, the issues being raised in the case, but I've got the statement of issues to be raised pulled up here. So this is kind of what's at stake in the underlying cases that have been filed. There are essentially two questions or two challenges that these plaintiffs have made to the FMCSA's non-domiciled interim final rule. The first is whether the interim final rule is arbitrary, capricious, or otherwise contrary to law. That's kind of a phrase that you'll see in a lot of these administrative cases. It comes out of the Administrative Procedures Act, which is what Tyler already mentioned. The Administrative Procedures Act, for those not familiar with it, is an act of Congress that essentially prescribes the manner in which federal agencies are to initiate rulemaking and pass rules. They have to do so within the confines of the procedures set out in that act. And it also sets out what will invalidate rules passed by administrative agencies, namely those that are arbitrary, capricious, or otherwise contrary to law. In other words, agencies aren't permitted to pass laws or to pass rules that are arbitrary, capricious, or otherwise contrary to the law. So essentially, the plaintiffs here, their first challenge to this interim final rule is that it is arbitrary, capricious, or otherwise contrary to law. And they will
Said
flesh.
another way, they didn't
Yeah.
have the FMCSA didn't have the support to
Yeah.
put they didn't. And I think the big thing is they didn't have the factual support, is what the plaintiffs are saying is, hey, look, you made this, and that arbitrary, capricious, that is language out of the APA, but hey, you have to explain yourself. And
Yeah, they're going
obviously
to have to
when we'll
flesh
get
this
in,
out. Yeah.
yeah, and the FMCSA gave some reasons, and we'll get into some of that, but
Yeah.
that they just didn't have the facts to support it.
So that it's essentially a substantive challenge to the rule itself, saying that the rule itself as passed is arbitrary or capricious in some way that will be fleshed out in the rest of the case, including, we've got a hint at it through the motions for stay, which we'll talk about in a minute. So that's the first big challenge to the final rule or the interim final rule. The second is that FMCSA lacked good cause to issue the interim final rule and make the rule immediately effective without following the APA's notice and comment requirements. So here is more of a procedural challenge to the rule. In other words, plaintiffs are arguing that the FMCSA, by initiating essentially an emergency rule that went into effect immediately before notice and comment, they should have just went through the standard notice and comment period. And if folks are familiar with that, usually the agency, proposes a rule, notice of proposed rulemaking, and then they leave it open for public comment for a period of time, usually 30 days. Then they solicit those comments, and then they go review the comments, and they make any necessary changes to the rule that they see fit based on those comments. And then they pass a final rule after the fact, and then the final rule will go into effect, at a certain date in the future. Here, with the interim final rule, the route that the FMCSA took here, kind of bypassed that typical notice and comment period and put the rule, the changes, the non-domiciled CDL changes into effect immediately as of September 29th. And the agency is now accepting comments to the rule after the fact, while the rule is in effect. And so here the plaintiffs are challenging that process. I mean, the APA does allow for that process, but the agency that is wishing to go through with that process has to be able to demonstrate that there were, justifications for going through that process rather than the normal one.
Yeah, and I think the kind of key on that, this good cause requirement built into the APA, is that it's meant to be narrow. We don't want administrative agencies to frequently kind of go outside of the typical, notice, comment procedures, right? We don't want administrative agencies just putting out rules all the time without any input or notice to the public. And that's one thing. It's based on existing case laws. Like, hey, that's supposed to be pretty narrowly construed, right?
Yeah.
It's not something that's supposed to happen all the time.
Right. Okay, so I mentioned that in the motions for stay, we get, and the FMCSA's response to the motion to stay, we get kind of a hint at what the plaintiffs are going to pursue in terms of the substance of their arguments here. So maybe we can just read the introduction to one of these motions for stay, and that will let you know essentially what the plaintiffs are arguing in this case. So here it is. So this is from one of the two motions that was filed. I'll just read it here for folks listening in. Here's the plaintiff's contention. So 3 weeks ago, on the slimmest of factual bases and without complying with the notice and comment rulemaking, the FMCSA issued its interim final rule threatening the livelihoods of more than 200,000 working people and their families. Under the rule, which FMCSA made effective immediately, immigrants who are legally present and authorized to work in the United States are barred from holding commercial driver's licenses required to operate CMVs such as trucks and school buses. In particular, the rule prohibits asylum seekers, asylees, refugees, DACA recipients from holding CDLs, thereby threatening their jobs and livelihoods with harmful impacts on the states, localities, school systems, businesses, and communities that rely on their essential work. FMCSA cited no evidence showing a connection between immigration status and public safety. Then it goes on to talk about who the plaintiffs are in this case. Says the agency's restriction on CDL eligibility based on immigration status is not the product of reasoned decision-making, and it lacked good cause to skip the notice and comment requirement of the APA. The harm caused by the rule is devastating, imminent, and irreparable. That's why the plaintiffs are seeking an emergency stay here. So, thoughts on that, Tyler? Kind of the bases for the action here.
No, I think they laid that out pretty well in terms of, hey, one, why we're seeking the stay because of the irreparable harm to these people who can't drive any longer, and hitting on the lack of factual basis, right? And that's obviously going to be fleshed out a little bit more, and it's going to put the FMCSA, and they responded to some of these things in their response to the motion to stay. So we'll see some of that, but I think as the court looks at the merits of this, there's going to be briefing and arguments, and the FMCSA is going to really have to put some of these facts together and tie it
Yeah.
to the non-domiciled CDL rule. And they did that, some of that in the interim final
Yeah.
rule. And I think they did that more than even they did in their briefing response to the motion
Yeah.
to stay. I think they threw some of it in, but I think one of the interesting things is, you know, hitting on the five accidents, right? We had the five accidents with the 12 deaths,
Hmm.
involving, folks that had non-domiciled CDLs. And I think that's one of the things that's going to be hit on is what factual bases
Yeah.
can you demonstrate FMCSA to support this rule?
And you can
And I
already,
think they're going to have to flesh that out.
yeah, I think that's right, because this is the question we all had when we saw this interim final rule come out, is like, okay, you're referencing these five anecdotal cases, and I get that, very high profile cases, and FMCSA comes out. Actually, Secretary Duffy comes out, and then FMCSA alongside him, referencing these five cases as justification for moving forward with something like this. But is that enough to warrant a rulemaking that severely limits who is able to get these types of licenses, or do we need more data that links, you know, these types of license holders to more substantial accidents, or a greater number of these types of accidents, or something like that? And we questioned whether that data even exists, and that's essentially what the plaintiffs in this case are arguing, saying, "Hey, where's the data that correlates these types of license holders to more serious or a greater number of these types of accidents?" So
Yeah, I
that's
think
what.
that's a good question. The one thing that the FMCSA says in their response is, and even, hey, look, imminent threat of life, right? I mean, should that show good cause? Hey, if some people are going to die, if we don't issue this rule, what is 12 people not enough? Does it have to be
Yeah.
30? And the FMCSA cited this in their response as well as, hey, there's no case law giving us a threshold, a
Yeah.
quantitative threshold of, hey, what threat to life is enough for us to show good cause? Are we saying that 12 people dying is enough? And I
Right.
think you're right. There's probably not the data out there. Maybe there is,
Well,
but
in fact, you and I mean, this stuck out like a sore thumb when I read the FMCSA's response. So FMCSA filed its response to the emergency motion for stay. And here FMCSA concedes that the data does not exist. Here is
yeah,
FMCSA's response. Indeed, as petitioners note, the rule includes in its discussion of benefits an acknowledgement that reliable data on a measurable empirical relationship between the nation of domicile for a CDL driver and safety outcomes in the United States does not exist. So FMCSA coming off that argument completely. And we'll get into, the FMCSA pivots here. They say that's not even the basis for our rulemaking in the first place. So it doesn't matter that we don't have the data, because there's another basis on which our rulemaking is premised. And that is kind of going back up here to, maybe I read the introduction to the motions to stay. Maybe I'll read FMCSA's introduction to its response to the motion to stay, so you can get a sense of what the agency is arguing in response. So here it is. FMCSA saying, because of the danger large commercial vehicles pose to other drivers, federal law has long set standards for the issuance of CDLs. From the beginning, those standards have required that the state issuing the CDL obtain and review an applicant's driving history from any state in which the applicant previously held a driver's license to determine if prior violations call into question the applicant's fitness for a CDL. States, however, cannot review similar driving history records of aliens not domiciled in the United States, as their driving histories are entirely or predominantly overseas, and states cannot compel the production of such records. And so it goes on to say that based on the risks inherent in granting CDLs to individuals whose foreign driving histories cannot be reviewed, the FMCSA promulgated its rule limiting non-domiciliaries' eligibility for CDLs. So the agency essentially is pivoting here and saying, hey, the basis for our rule was the fact that the states can't always get access to the driving histories of the folks who are applying for these types of non-domiciled CDLs. Thoughts on that, Tyler?
Yeah, I mean, it's an argument, but I guess I look at it and it's, well, all the same standards exist,
Yeah.
right? In between non-domiciled CDL holders and, you know,
They got to pass the
other
same
CDL holders.
test. They got to
It's
go
this,
through the same training,
yeah,
restricted in the same ways, same classes of CDL, same, in fact, some limitations on them that don't even apply to standard CDL holders. Can't have a hazmat endorsement, for example, if you're a non-domiciled CDL holder. So
yeah, and I thought the plaintiffs here made a fair argument with respect to at least the DACA recipients is they've been here since they've been kids.
yeah,
You know
right,
that, and I know that's a subset here, but it's kind of another hole to poke in that general argument is, well, all right, then what percentage of the non-domiciled CDL holders are we talking that are, that we actually states are able to find their driving history,
yeah.
right? And again, I don't know if that data exists or not
And
as well.
I think that's right. I think the $1 million question then is, okay, FMCSA, if the court is to buy your argument that the inability of the states to compel production of the driving histories of these non-domiciled CDL applicants is a safety concern, then what's your justification for allowing any non-domiciled CDLs? You're going to allow them for H2A, H2B, and treaty investor drivers. Are you able to get their driving histories? Is that what you're saying? And you and I have talked. FMCSA responds to this argument, and they say, well, yeah, those types of drivers or those types of employment authorizations are for employment-specific purposes. And essentially, I want to get this right because I find this argument a little bit specious. Let me get it here. Um,
I think it's on page 7, the
yeah,
employer vetting process that ameliorates concerns about the lack of access to their foreign driving
yeah,
history.
yeah. The
So, yeah,
FMCSA. Go ahead. Yeah.
no, you go ahead, please.
Yeah, so the FMCSA, in their response to this argument, says the rule explains that aliens who receive visas premised on their employment in the United States generally undergo an employer vetting process that ameliorates concerns about the lack of access to their foreign driving history, including a check for a U.S. CDL, related work experience, clean driving record, passed a drug and medical test. Additionally, because it can be time consuming to sponsor a new individual to replace an H2A or H2B visa holder who is no longer able to work, employers have strong incentives to exercise diligence in screening individuals sponsored for those visas. So, in a nutshell, FMCSA is saying, well, because those particular categories of foreign nationals that we're going to continue to allow to get non-domiciled CDLs, because they're here for employment, the employers of those have an incentive to check their driving histories and stuff like that. So we're comfortable with allowing them to continue to get these licenses. And you and I are like, well, wait a second. Anybody getting a CDL is getting a CDL for an employment purpose. You're not going very except in limited circumstances. I think California requires a CDL for like RV drivers and stuff. But vast majority of folks getting a CDL are getting it for employment purposes. So to say that it's just these category of employment visa holders that are the ones that are doing this for employment, I think is a bit disingenuous, and it kind of blows up the argument, right? Because presumably the asylum seekers who are getting a CDL are also getting it for their employment purposes. And why wouldn't their employers have just as much incentive to check their driving history as the employers of the H2A or the H2B visa holder? So that was my initial reaction to that argument. It
Yeah,
seems a
I mean,
bit
I agree.
problematic.
If you're getting a CDL, you're getting a CDL, right? And it's that one fact of, hey, we're not able to check their driving history. I don't see the FMCSA demonstrating that these other non-domiciled CDL holders
Yeah.
Do we have any evidence that they're actually checking driving history?
Right. Right. Yeah, that's a problem for their argument, I think. So that's the type of stuff that's going to get, fleshed out in the motion for stay for sure. And if the court thinks that the plaintiffs have a good argument, a good chance of success on the merits of their case, then maybe they decide to stay this rule for even longer, pending the resolution of the case. Let's see here. Brian's saying the problem is the fraudulent schools issuing the CDLs through the ELDT program. I think that is the underlying issue that needs to get resolved. I think Brian's exactly right.
Yeah,
Uh,
and that's outside of this too,
right.
right? I mean, you have schools issuing CDLs when they shouldn't issue CDLs.
Yeah.
That's not,
Yeah.
hey, you can't issue CDLs to, foreign nationals.
Yeah.
You're giving out CDLs. It could be an American citizen, right? And they're giving out fraudulent CDLs or not qualifying people the way they should.
Yeah. It's hard to see this as anything other than political, as we've already said. And that's not me saying, I think it is a worthwhile exercise to crack down for FMCSA to crack down on the states and say, hey, your issuance of these non-domiciled CDLs has to be within the confines of the rules that we set up. And so to the
Yeah.
extent you are issuing these non-domiciled CDLs for longer than what we have authorized you to do, certainly FMCSA should be cracking down on that. The question of whether they need to go the next step and limit the availability of these non-domiciled CDLs to a smaller group of foreign nationals, that's where it starts to get wrapped up in the politics of it, right alongside English language proficiency. And I worry that it's the politics driving it more so than the policy things that should be driving rulemaking, really.
Yeah, and I think as part of the politics, as you mentioned, these accidents, these high-profile accidents involving foreign nationals. I mean, it looks terrible, and it's always just devastating to see people dying, on our nation's roadways, and I think that it's a politicized event, and it makes it easier for the government to say, hey, we're doing something about it. See, we're doing something about it,
Mm-hmm.
right? But I also kind of wonder, what kind of market pressures play into this as well. Because I mean, look, we've been in a pretty severe freight recession for 3 years plus now, and there's been people that just want a reduction of capacity towards getting the rates back up, and you kind of wonder, hey, what kind of lobbying or
Mm-hmm.
backroom discussions were, hey, how can we reduce capacity in a
Yeah, right.
way that goes along with the politics of it too, to say, hey, yeah, we can reduce some capacity pretty quickly, make people feel safer on the roads, and hopefully potentially help the industry as a whole.
Yeah. Yeah, so I mean, it is what it is at this point. This is going to get litigated here for now. So maybe that's where we'll leave it. Is what does this stay do exactly? What does it mean? It means that interim final rule, as if it never happened. It takes us back to the status quo before the interim final rule, meaning that technically anybody who met the standards under the old non-domiciled CDL rule could potentially go get a non-domiciled CDL. Whether the states are going to be open to processing those requests right now with the current climate and the current environment and pending further court action, that's a different question. I don't know if the states will be open to that or not. There's nothing that's forcing the states to issue those licenses at the moment. And that's something else that you and I have talked about, which is, going back to the point I made at the start, which is that ultimately this non-domiciled CDL program is an FMCSA program. I mean, they could potentially get rid of it altogether and still be within their authority to not issue these because, you and I looked at kind of the congressional directive, the statutory authority that FMCSA has with its CDL program and these non-domiciled CDL in particular. Congress's directive when it comes to non-domiciled CDLs isn't all that specific to begin with. We didn't see anything in there. I mean, it was a quick read, but we didn't see anything in there that mandated FMCSA to authorize these types of non-domiciled CDLs. It did prescribe some basic requirements if it's going to do it. It said that FMCSA may issue these types of non-domiciled CDLs in these particular instances, but nothing that seemed to force FMCSA to issue them. And
Well,
so,
what I think is interesting is the underlying statute says states may. So it's really giving the ability of the state to do so. They're not forced to give these, right? And as you mentioned, the FMCSA prescribes the requirements, right?
yeah,
The qualification requirements, but it's almost a right given to the states to, and the states are issuing the CDLs,
yeah,
and that they don't have to.
yeah. Something else we talked about briefly between us that's worth mentioning is something that happened last year at the U.S. Supreme Court, which was the overturning of Chevron deference. We did a show on this last year. If you're interested in a deeper dive into what exactly that means, I'd encourage you to go check out that show. But for many years, for decades, federal courts were bound by a decision in a case involving Chevron. That's why it's called Chevron deference. But in that Chevron case, the U.S. Supreme Court had essentially said that when it came to matters of an agency interpreting its statutory authority, in other words, if we have a case involving an administrative agency, a federal agency, and the plaintiff is challenging the agency's interpretation of its own authority to act that has been given to it by Congress, we are going to, the federal courts are generally going to defer to the agency's own interpretation of its authority. In other words, the court isn't going to substitute its judgment for the informed judgment of the agencies, which are supposed to have the experts on the topic at hand. And so that Chevron deference was a pretty strong influence on federal court decisions involving federal agencies for many years. I mean, it essentially let agencies do pretty much what they wanted to do, barring extreme cases. But that was overturned last year in what was it, the Loper Bright case?
Yeah, Loper Bright Enterprises versus Raimundo. But again, I think yes, that is with respect deference to the agency with respect to its interpretation of Congress's laws that enable them to pass regulations. The APA itself, however, does, and again, the APA law passed by Congress does give separately agencies some deferential treatment in determining whether something is a rule is reasonable.
Yeah.
So
So still,
here,
yeah,
I mean,
that's a good point. So there's still deference under the APA given to
yeah,
agencies in their rulemaking activity. But when it comes to whether the agency has exceeded their statutory mandate to begin with,
yeah,
it used to be under Chevron deference that we would defer to the agencies even under that, which never really made all that much sense to me, that we're deferring to the agency to say, yeah, we acted in accordance with what Congress gave us. And so, it'll be interesting to see if that has any bearing on this case where, to your point, to the extent the plaintiffs are challenging the substance of the rule, maybe the court defers to the FMCSA's expertise in knowing about highway safety and that type of stuff when it comes to the substance of the rule. But to the extent the plaintiffs are arguing that the FMCSA exceeded its authority, its statutory authority, by, I think the argument that they would make is this isn't a safety-related rule. This is essentially FMCSA making a de facto immigration rule that says these types of immigrants can't get licenses. I think that would be the plaintiff's argument. And by
yeah.
doing so, they would say FMCSA has exceeded its authority granted to it by Congress, in which case
Mhm.
I don't think the court would defer to FMCSA's authority to decide whether they acted in accordance with that authority or not. So it'd be interesting to see how that plays out in this case. I think this will be the first test for that in the context of FMCSA, the removal of the Chevron deference. So should be fun
Yeah.
to
And
watch.
I mean, I think the FMCSA's, I mean, they've got a difficult directive towards, you know, highway safety and, obviously laws passed by Congress that are pretty broadly directed at that, which I think is for a long time given them, a lot of ability to do a lot of different things from a regulatory standpoint. But yeah, I mean, we'll see what the briefing and specifically how the plaintiffs here are gonna challenge the FMCSA's rule here.
All right. Anything else we haven't covered here, Tyler, that you can think of?
No, I think we hit on the high points.
Like I said, we didn't really have a plan for this show. We just wanted to jump on here and talk about kind of the development and what it means immediately. Again, thing to watch out for here. The next thing that will probably happen is that the court will rule on whether this stay is going to stay in effect, whether the interim final rule is going to be stayed for longer while the court, hashes out the merits of the case. And we don't know when that next decision will be made. Probably, if I had to guess, probably within the next few weeks, I would guess. I don't think the court wants this kind of lingering out there where they have stayed a federal rule for any longer than they really need to. So we'll see. But certainly any updates to this case or non-domiciled CDLs in general or English language proficiency, we're staying on top of that at Trucksafe. So again, if you want a resource to keep on top of that, I'd recommend you follow us on our various social media pages or our newsletter, trucksafe.com/subscribe is where you can find that. Tyler's also been writing about this topic on his Shipper's Interest website. Tyler, you want to kind of give a 30-second plug for Shipper's Interest and what you're doing over there?
Sure, yeah. So Shipper's Interest Consulting is focused on helping shippers better understand their transportation vendors, warehousing vendors. I've found over the years that a lot of shippers, and this can be manufacturers, retailers, distributors, treat their transportation vendors just like another vendor without recognizing the risk and insurance and some of the legal background under which this industry operates. So definitely educational towards helping shippers better really interact and understand their transportation and warehousing vendors.
Yeah. So Tyler's watching this from that perspective as well. And also another big thing that will be coming up, I know we should probably also do a show on this, is U.S. Supreme Court taking up the broker liability issue. And so we'll be watching that closely. I know Tyler will be watching that for his third-party intermediary clients. So yeah, check that out. What's the website again if folks are interested? Shippers and brokers.
Shippersinterestconsulting.com.
There you go. Check that out. All right. That's all we had planned. So I don't see any other questions here. So I guess we'll wrap it up for the day. Appreciate you all being here. Again, happy Veterans Day to everyone. We will catch you next time. See you.